All right, welcome everybody to Legal Tech Week for December 6th, 2024. I apologize, I am in the Miami International Airport on my way back from the Legal Tech Fund, the TLTF Summit, third year of that. I'll tell you a little bit about it in a moment, but I may also have to get off the call before we get through the whole call, so we'll hand over the moderator reins to somebody else. Um, but before we get to any of that, let's introduce this week's panelists. And Nikki, you want to give us the finger? I mean, kick us off.
Nice, nice.
Did you say flip us off, Bob, or kick us off?
You have to now. You have to explain, but
They're gonna have to explain it.
Well, all right. So first, I'll introduce myself, then I'll explain it. My name is Niki. I'm a legal insight strategist at Affinity, parent company of My Case, LawPay, CasePeer, and DocketWise. And I write legal tech columns for AB Journal Above the Law and the Daily Record. And I just had mentioned to everyone before we got on this, before we went live, that yesterday in a meeting, somebody said something, a work meeting with Affinity. So somebody said something and I wanted to support it, so I posted an emoji that was, finger pointing upward, like, yeah, that. And one of my colleagues messaged me and said, I'm not sure if you know this, but that was the middle finger that you posted. And it was this emoji was the top emoji that appears on Zoom for me because I use it all the time. So I've apparently been flipping people off a lot unintentionally. So if I flipped any of you off, I greatly apologize. And now I know that there are two emojis with fingers pointing upward. And why, by the way, is the middle finger available in a professional setting? Like, why is that even an option? I'd like an answer to that question too. But so
That seems obvious to me, but okay.
Yeah. I can think of various situations that could come in handy.
you can ask why emojis are even allowed in a professional setting, but that's a different topic, I guess.
that's a good point.
All right, Victor, how about you?
So now I'm looking for this emoji and I can't find it.
I'll share it in a minute. I'll find it.
I am
My
Victor
Case
Lee.
thing.
Maybe it's an internal thing. My name is Victor Lee. I am assistant managing editor for the ABA Journal, focusing on business of law and technology. And like I was telling these guys, my top emoji on my phone is the poop emoji. I'll just leave it there.
All right. Now that I'm looking at that in the chat, I'm wondering how you did not understand what that was. But okay, we'll leave it there.
Okay. I
okay.
can see it. Yeah, okay. All right.
Yeah. All right. Joe, how about you?
Joe Patrice from Above the Law and Thinking Like a Lawyer, the podcast. I am, I don't use emojis hardly ever. I'm of an era where I learned the emoticon thing, and I will still hit my colon dash close parentheses whenever I'm trying to say something.
All right. And maybe last but not least, we're not sure if Stephanie Wilkins is showing up or not today, but Steve, how about you?
Hi, I'm Steve Embry. I write the blog Tech Law Crossroads, and I very rarely use emojis for fear that I will put an inappropriate emoji when I hit one.
And, Steve, I just want to say, I mean, you've posted publicly on Facebook about the very sad news that your wife passed away this week, and I just want to express condolences publicly to you.
Thank you.
And we're all really really sad about that, and you're a dear friend to all of us, and we feel your pain. So sorry.
Well, thank you, Bob. It was not unexpected, but that doesn't necessarily make it easy. So, but thank you, appreciate it.
In the more bad news department, Jean O'Grady let me know that she's going to step off the show from now on. She's been a regular for a while on the show. As a lot of you know, Jean is retired and has decided she's also going to retire from writing at all about legal tech. So she just felt that she wasn't going to have much to contribute. wasn't really going to be trying to stay on top of what's going on in the legal tech world. So Jean is going to be stepping away from the show. I asked her to perhaps come on this week or next and say goodbye, and she's on the fence whether she even wants to do that. She's been traveling a lot and going around a lot. So sorry to see Jean go, but but that. And on those sad notes, I'll just start off a little bit by just talking about where I am. So I was spent this week at the LTF Summit, which is the conference put on by the Legal Tech Fund. This is the third year of it. And it was in Miami this year, out on Key Biscayne at the Ritz-Carlton, not a bad location for a conference, which all legal tech conferences should be there. And this conference started 3 years ago. They had 140 people there the first year. Last year, 300. This year, 500 people. It's what I was told, and somebody else told me they thought it might have even been more than that. Apparently, they were told by Zach Posner, the organizer of it, that in fact they thought that there were a waiting list of another 1,000 people trying to get into this conference. So it's an invite-only conference. A lot of people have requested invites, but they shut it off at 500. But once again, a really good conference. I previously described this as like the Davos of the legal tech world. What's interesting with this conference is just it's a unique mix of people that you just don't see at any other conference. There's a lot of investors here, a lot of VCs and private equity type people wandering around, but a lot of very well established founders, a lot of startups, a lot of people who are sort of on the periphery of legal tech, lawyers. I was talking to one person who's a lobbyist who represents legal tech companies and trying to get state laws changed to allow things like digital signatures on wills and things like that. So a really interesting mix, and a conference where it's consistently the best part of it are just all the conversations that seem to happen in the hallways here, as opposed to, I mean, the programming was good, some really good panels, but it was not a single person I talked to at this conference who didn't say they thought this was the best conference they'd been to this year, including some grizzled old timers among them. So we all need to work on getting here next year. And I don't know where they haven't said where it's going to be or what the number of registrants will be. I'm assuming they're going to expand it a little bit. I'm sure it'll be somewhere in the Miami area since that's where Zach is based. But a really good conference. Since none of you were there, none of you can share your insights on it, I guess. I had thought Stephanie was going to be coming, but I think that changed maybe when she changed jobs or something. But plenty of people from her organization there as well, from the Legal Tech Hub. Overall, just a great event. Also, really good food and a ton of swag. Awesome swag.
I had a lot of FOMO. It seemed like everyone was there. I don't know why. If it doesn't have to be a conference, but it felt like everyone was there.
It felt, including your boss was there. I saw Drew speak, and a bunch of people from Affinipay, in my case, were there. It felt like everybody was there in a way. I mean, you would have known a lot of people there, but it was interesting that there are also a lot of people that never met before, and so that made it interesting. And like I said, Florida, so Miami. So where do we want to start this week? Niki, I was actually having a lot of conversations with people over the last couple of days about access to justice, and there were several people here who are actually working on some areas of access to justice, including, I understand there's going to be a kind of a follow-up report coming soon on that Stanford study that had been done on the Utah and not Utah. Utah and Arizona programs, and you did a nice piece this week on some kind of giving some concrete examples of what that means in practice. So, you want to talk about that?
Yeah. Okay, great. I was just going to mention that someone said the background noise might have been challenging. I just posted a link. I had written a prior piece. I think it was for the Daily Record, where I'd spoken about 2 different platforms, and I decided to kind of do more of a deeper dive, partly based on a post to Bob, had up where a few other people responded. And then I also did some additional research and located a number of other examples of where chatbots were being used by courts or legal aid organizations on their websites to assist pro se litigants, possibly lawyers, I don't know, to assist people visiting their sites and navigating the court system. And I think this all sort of stems from, the reason I've been doing a deep dive into this type of thing is it stems from when we all had that panel at CleoCon, and afterwards, when I had taken the position that AI was not going to advance access to justice because capitalism trumps altruism. And afterwards, Jim from Oklahoma Bar came up to me, Jim Calloway, and said that he respectfully disagreed when you put AI in the hands of legal aid lawyers. It enables them to streamline their work, get more done, represent more clients, and represent them more effectively. And he raised a really good point. So I tried to broaden my perspective on what does AI mean. It's not just funds going into tools that will somehow in and of themselves be focused on expanding access to justice. And instead, how are legal aid organizations or legal aid attorneys or the courts using these tools in ways that might help a layperson navigate the justice system? And so that's why I kind of went down this road a little bit and sought out some more examples. And I just talk in the article about how it's a start, but I still do feel like until we have significant funding behind this, probably from the government, I just don't see how capitalism isn't going to win out. And ultimately, a lot of these efforts just aren't going to actually bridge access to justice in a really significant way. I'm not entirely sure that they're really going to get funded and make a big difference, but it's at least, the more there are different ways of trying to create these bridges, maybe eventually we'll have multiple paths towards access to justice and put them all together and you've got access to justice. I don't know, but it's interesting to see the different ways it's being approached.
Yeah, I would add, I did in terms of sort of traditional, we talked a lot about in the show, I think, about sort of traditional applications being used in the A to J context. We talked about the Relativities program to make its software available. I did a podcast this week that I recorded back at that Everlaw Summit on the Everlaw for Good program, where they've, in the particular example I recorded this week, had two people on for this from the center that works on bringing civil lawsuits for atrocity crimes. Basically, when international war criminals end up living in the United States, this organization tracks them down and brings civil lawsuits against them for their human rights crimes and atrocity crimes. And so they've been using Everlaw's software to be able to go through, often just like a lot of these cases, just tons and tons of documents that they have to go through, and often old documents that are like scanned from like the 1980s or something when some of these crimes actually happened, and often in multiple languages and sometimes handwritten, and all sorts of a mess of documents. And so Everlaw's AI tool has been able to help them. So that's an example where it's a product built for commercial legal applications, but where it has really strong applications in the A to J space.
And I agree to an extent about the idea that like capitalism is always going to, be the primary motive, but also, looking good is part of that too, right? And so if these companies like Everlaw or these other companies like like I see LawDroid on here and some other ones, it makes them look good. It makes them look responsible. It makes them look so like they're trying to help solve a problem, like a real problem. And that can also have an impact to this idea of, well, if even if I might be motivated by other I'm not saying these people are, but like even if it might be motivated by other things besides just trying to bridge the access justice gap, I can still do a good thing.
And you also can't discount the fact that the price of many of these tools, if it follows the curve of most technologies, will decrease over time. And as it decreases, more and more people could have access. It's similar to, smartphones. When they first came out, I remember the shoe phones that you had to lug around that cost a fortune. And then when the phones got cheap enough that everybody ended up with one, it wasn't just a ploy for the rich. So that's a factor. Maybe, I hope, anyone.
Well, I mean, there was a comment here on how, I'm not sure how loosening UPL might affect A to J, which I think is an interesting comment. I mean, I think there's clearly an assumption that loosening UPL enables more companies to develop more technologies that are in some ways either direct to consumer, delivering legal help in some way, or just enabling developing, just encourage. It's an incentive for legal tech companies to be able to invest money into a sector where right now some of them are reluctant to invest because they worry about UPL laws. But I think it opens the door. I think loosening those laws opens the door to innovation. That's what's happened in Utah and New Mexico, New Mexico, Arizona. And if you look at the first Stanford study that came out like a year ago or so, 2 years ago, looking at the data coming out of Utah and Arizona, clearly loosening the UPL rules have clearly promoted some innovative startups to get going there.
Yeah, I think that's all true. One of the things though about access to justice conversations is, it's similar to how law school works. It has this litigation first focus that isn't necessarily appropriate all the time. Whether or not AI is going to help people resolve their legal cases in some way that's cheaper and better and more efficient is not really, that's a harder thing, but not a reason, a harder hill to climb, but not a reason why legal tech products and UPL can't do a lot for access to justice, because there are so many opportunities where you don't need to go into a courtroom if the contract was done right in the first place. If the agreements are done right, your licenses are done right. Like when those sorts of transactional documents, which a lot of people blow off because it's too expensive to hire a lawyer, if a lot of those go right, then they don't need to get to court. Obviously, that's not like the indigent client base, but the low income to now lower middle class number of folks who can't access justice at the litigation level, theoretically would have fewer issues if we open that up on the front end. I think you're muted.
Yeah, no, I am. My little space bar trick doesn't seem to be working. So yeah, I just wanted to comment to somebody else about the companies will still chase profits, and any A to J progress will be ancillary. I mean, there's nothing wrong. There's not the profit motive and serving A to J goal are not necessarily mutually exclusive. And I mean, there are a lot of companies that are part of that justice technology organization that we've talked about before in the past, but they're all profit-making companies. They're not, they're not nonprofits or something, but their goal is to enhance access to justice. And I think you can be both a profit-making company and serve the goal of access to justice. But,
yeah, it's like the J-bonds principle that if you lower the price point, then you make up what you lose because you get a lot more volume. So maybe that could have an impact as well.
just one other comment on Niki's article. Victor, do you say something?
I was gonna say also, I mean, UPL and A to J aren't exactly mutually exclusive either, because it's just like, I think the idea is that it has to be one or the other, and it's just no, not necessarily. I mean, well, first of all, it's it's going to be a cold day and where until until we see all the UPL rules just get unilaterally relaxed, state to state or jurisdiction to jurisdiction. So, but the thing is, I think the idea that if existing lawyers who can use technology to better serve more people, even if it's just like a chatbot that can allow them to do more for people rather than just taking on these cases and whatnot, then they will have served more people than they would have been able to otherwise. And so, it's an incremental thing, but it's not necessarily a case where it's like lawyers are either just gonna, sit on their hands and do nothing, or wait for the rules to get relaxed and then they have their jobs taken away. They can be proactive and they can use these tools to their advantage, but only a few really are.
Yeah. Just one other point I want to make on the access justice issue. If you haven't ever been, that Legal Services Corporation's Innovations in Tech Conference is coming up in January in Arizona. Very good conference. It's all focused on developing applications for serving low-income clients or people who otherwise don't have access to legal help. And there's two TACON conferences this year, one the day before and one the day after, apparently both of which are focusing on Gen AI and access to justice. I think one has maybe a more academic setting and one is more practical. Kristen Sonde is organizing one of them. And I think the Arizona College of Law, Arizona State University College of Law, I think, is involved in organizing the other one. But so there are lots of good reasons to go to that conference if you're interested in this area this year. All right. Joe, I don't know, Pacer breaking down or Elon Musk or Elon Musk breaking down? Which do you want to talk about?
All right. Well, I'm gonna start with Elon, and only because I feel like it's a natural segue from what we were just talking about. As we were just discussing ways in which legal tech can make everything easier. Elon Musk, who is an idiot, was talking about how he says his new version of Grok is going to be fed all the court cases and therefore be able to render really compelling decisions. I'm skeptical of this a little. I think the idea that you could just put a bunch of cases in and have an AI not only dispense good advice, which we've seen it's not particularly great at anyway, but to be able to do well. And by not great at anyway, I'm saying there's a lot of people spending a lot of resources and who have a lot more expertise than anyone he's working with, who are working on making sure that when AI says, something as hallucinatory as Timothy Leary on a bad weekend, that it can be contained and prevented from getting outside of where it needs to be and infecting the process. The idea that without any of that work, you could just put all this in and not only get good results that people could therefore operate on without having lawyers, but also that it would replace judges is so ridiculous and indicative of how he runs his companies, which is why things blow up a lot. I think that said, my ultimate point was I think the real issue with this story, put aside that no, you can't do this as a tech issue. I think it really speaks to the disdain that some of these people have for the legal system. They don't think that anything that lawyers do is serious or important. They think that it's something that they can hash out with what was that program with the little turtle that moved, Logo? I think that was the programming language from like the early 80s. They think they can plug that out and replace learned hand with it, and they cannot.
Well, you know what this reminded me? What is the old saying about, like, if you have like 1,000 monkeys typing on typewriters at the same time, then you can end up with Shakespeare. It's like that, only now with artificial intelligence. So all right.
I think somebody recently, I read something where some study was done where they worked out the numbers and said, in fact, 1,000 monkeys would never get there. So now that's not even on the table.
Somebody in the chat made the very good point that what's really driving this is Elon is just pissed off that the court rulings haven't gone so well. He'll fix it.
Absolutely.
He'll bring fundamental fairness back to the process.
Well, and the other thing, if it was that easy, why wouldn't there be commercial providers out there building it as a product already? In a sense, I mean, I was just talking. The last person I talked to on my way out of this conference today was I ran into Pablo Arredondo, who, like, from co-counsel creator now at Thomson Reuters, who, like as Pablo likes to do, would, pulled out his laptop and wanted to show me what he was working on. And what he's working on is this project with the appellate courts in Massachusetts to essentially help them generate their opinions in cases where you can kind of load in. I mean, he's showing me, I got to drag in the briefs, drag in the case record, drag in all the transcripts and whatever else there is, dockets and all of that, and it's going to generate it'll generate the sort of the findings of fact and the statement of the issues and all of that kind of stuff, but it stops at deciding the case or at playing the judge role. So it's really interesting. And he said that, they're just, he doesn't feel the technology is there yet to be able to sort of do that part of doing the judging role. So, obviously you can use this technology to shortcut a lot of the steps in it, but not to the point of actually replacing judges. Yeah, Elon's an idiot in that sense. But
although there is some argument for there being a certain level of dispute that it would make sense to have an automated decision, like the eBay dispute resolution thing that's been around for a while, and kind of brings it back to access to justice. There are a lot of people with legitimate disputes who can't bring them because it costs too much to hire a lawyer or go through the process. But if there was an ability to get those things resolved quickly and easily, I mean, a lot of people might say, like people do with eBay, yeah, if we get it resolved in 3 or 4 days, yeah, I'll take it. Win, lose, or draw, at least it'll be resolved. So
My concern is probably threefold. I'm not sure if I have 3 points, but just pretend I do. First of all, to this, like from an overarching perspective, I just saw an article today that had some data about employees. I think it was actually one of LinkedIn's top trending stories, saying that most employees right now are reporting that AI is making them feel more overburdened. They're expected to do more work. So it's that same thing we all thought we'd be like, have robots running around doing our work like the Jetsons, and instead, every time new technology comes along, it just puts more on our plates because we're expected to be more efficient and more productive. And so my concern is that is already seeming to be happening. And then when you apply that concept to judges and their clerks, and courts are already overloaded. They have too many cases. And so are they going to start to feel like they can rely on AI as a shortcut for the facts? And that concerns me because when I use generative AI and try to get it to sum up something, to provide a quick summary, to provide a list of relevant facts, whatever the case may be, it doesn't get the nuances because it isn't a trained lawyer. It's not me who's read it and is trying to get to a particular point. It hasn't done it just doesn't have that backdrop. And so my concern is that there may be, if you have an overloaded court or an overloaded clerk and they're having a frazzled day and they're just trying to get through it so they can get these cases done quicker, that it may miss this really important point. Granted, that's the job of the litigants in oral argument or whatever the case may be to bring that out, but you also want the court to pick up on that. And so it concerns me that they could potentially rely on generative AI for that aspect of it, when I really think that those are things the court should be doing on their own, not having to write the entire brief for them, or even the beginning of the brief, but more helping them summarize it so that then they can do the deep dive and write the brief themselves, right? After they've reviewed all of the information. You're supposed to review it, right? So I think I have 2 points, not 3. So let's just go backtrack. I had twofold, but go ahead.
Well, I was actually going to throw in that before, after he left the bench and before he got sick, Judge Posner had a case where he was making the real argument, which I thought was very compelling, that there's serious injustice when you can look at an opinion and the judge has just pulled whole block quotes of the facts out of them. And he was arguing that this is indicative, in that case, it was a pro se situation, of how little the courts cared about those cases, but also when you parrot the more powerful interest in the discussion of the facts, you frame the whole opinion in ways that are problematic. And I thought that was a really compelling conversation he had about it. And that strikes me as a real risk when you have something like AI just going through all the briefs and being like, here's what we've decided the facts are, because there's a little more to it than just a rote timeline.
And I was going to just bring up what people are talking in the comments. That was my third point, was the biases, and how when you apply the biases on top of it, especially in criminal cases, who knows what the AI is going to emphasize, in terms of the relevant facts. So I think there's a lot of problems with that, although I applaud Pablo. He's so creative and does some wonderful things. So who knows, I don't mean to pick apart his concept, but I do have some concerns about it.
Well, the other thing he showed me was, I guess, another procedure in Massachusetts I didn't even know about, but if in housing court, if somebody gets an eviction order against a tenant Maybe it goes both ways. But if you get an order in housing court, eviction order in housing court, there's an expedited appeal process. It's like a 3-day appeal or something like that. And there's this whole process by which the clerk of the housing court has to assemble this record to hand on to the judge. It's not just all the docket entries and filings and everything, but actually a summary of the case and sort of a summary of what happened at the trial level. And so another thing he's showing me is now they've automated that. They can create this. They can basically take everything the clerk was doing and create this document for the hand of the judge. Again, they're not deciding the case, but they're giving the judge everything so that, you know, the clerks aren't burdened with having to run around and do this stuff that needs to get done within this 3-day time span or whatever. The 3 days may be wrong, but it's a very expedited time span. So again, a really cool thing. And it, you know, the other thing is, again, we keep talking about the fact that this technology is really in its early days, and it hopefully is going to keep getting better and better and better. Zach Posner, in his keynote at the TLTF Summit, reminded people of when the iPhone first came out. What was the best-selling app originally when the phone came out? Does anybody know what it was? It was. Does anybody remember the one when you like tipped the phone and it would look like beer pouring out of your thing? In the early days of the iPhone, that was the best-selling app. So he said we're like in the beer pouring days of generative AI right now. You know? And we'll see where this all goes. But I like that analogy.
Well, I mean, I can see the point of this technology for, you know, if judges are overworked or they're overburdened, or this is a way to kind of get more cases in front of them. But look, come on, you judges are there. You got clerks. You know, these clerks work their butts off in law school to get those jobs most of the time. So let them do their job. I mean, I don't know.
Well, the federal court judges have clerks. I don't think many state court judges do. And so they're you know, they have huge caseloads. So they're always scrambling. Most of them have, other than Judge Shagel, you know, who's crafted his own technology, most of them have little access to technology to, you know, to be more efficient.
We have clerks in our county, the court judges, which are the trial court level in New York. But I don't know how rare that is.
But by clerks, I was talking about the clerks who process, the administrative clerks, not the law clerks, but the clerks who process the cases and take filings and assemble records and do all of that, you know, administrative work. The people who stand at the front desk when you walk into the clerk's office at the courtroom or the courthouse and have to do all of that administrative work. So yeah, let the well-paid clerks, but that's a whole other issue. Yeah. What about Pacer, Joe? Did you want to also touch a little bit about that? Because that was an interesting development.
Sure. So this was interesting. So Pacer has developed this situation. I don't know if anybody has been using it, but Pacer's developed a situation where it grinds to a halt, basically from around 10 a.m. Eastern till noonish or a little later. It's been shrugged off as some sort of a bug for a while, but the Southern District of New York confirmed that they've been looking into it, and it's all the journalists' fault. All the journalists and data miners and everybody, this I assume would include our friends at places like Lexis and all. It is their go. Everybody is choosing basically 10 a.m. Eastern all across America is the moment that all of those people begin their power using of scraping tons and tons of Pacer content. This is also, of course, when a lot of people are lawyers who actually need it for real work are showing up for business. And so that's adding to the problem. The story even included some allegations that there were judges in the Southern District who were reading opinions from the bench because they'd loaded it up, but it hadn't been visible because it was slowed down in the process. So by the time of the hearing, nobody had seen it yet. So they were reading these things because they hadn't been distributed. A real problem. It is hand in hand with the conversation that we've talked about a lot about free Pacer versus, I guess I should say, the judiciary's claim that they need like $2 billion to make Pacer work right. It seems like the answer is probably not fees because the power users are paying those already and certainly doesn't seem to be causing a difference, but some sort of you have to do it overnight. If your login is going to get more than XYZ amount, you have to do it overnight. Whatever it is, something needs to be done.
I think there is, in fact, that rule in some of the state courts based on, I may be wrong, but I know some of my conversations with Gavin at Pacer Pro, I'm pretty sure like the LA courts have a specified time when the vendors can go in. It's like overnight kind of thing, when the vendors can kind of go in and do their data downloads for the day, which would, why Pacer wouldn't just do something like, of course, then you have to figure out the time zone and all that, but that would make a lot of sense. But yeah, it's broken, and it's broken in so many ways. That's only one of them, I'm afraid.
And separately, I just wanted to say this is that with your writing, Joe, I really appreciate your like sharp wit in the writing, and then your sharp, your quick wit when you speak is even more impressive because I am not good at that. So, but like sometimes your articles just make me laugh out loud, and so I like the phrase you have sometimes.
Thank you. When I referred to Pacer as basically a broken GeoCities site, no, it's
It's good.
It's between that or Angel Fire, right?
My CompuServe, All right.
That was John Trenanek, if you didn't recognize who that was, the founder of Merlin. All right, I'm going to have to get going here, so I'm going to turn this over to Joe. I turned hosting duties over to Joe, and see y'all next week. Mm-hmm. All right. Bye.
Have a safe trip, Bob.
Yep. All right, ultimate power. Now everything is mine. There doesn't seem to be a ton of power involved. I just have to turn it off when we're done. But in the meantime, Victor, you have a story on the docket here.
Yeah, so basically, talking about law school, because it's not technically a law, not technically a tech thing, but I kind of make it into one later. I'll bring it back. So, law school applications are up a ridiculous amount of money, a ridiculous amount right now. And I think the story that we posted yesterday, they're up an unnatural 35% from this point in 2023, and that's just applications. The number of applicants is up by 25%. And it's across the whole country. There's no like particular region that's getting that where the people are coming from. It's like 38%, 38% increase from people from the northwest, 30% from the northeast. So people have different reasons for what's going on. Some people say it's just like with any presidential election, we tend to see more applications in general, but especially this past election with everything that was at stake and just the increased interest in things like that. And in 2016, there was an increase in applications as well, that not as much as this one, but yeah, it just kind of begs the question of sort of like, what will these lawyers then do? Well, they're not all going to be practicing lawyers, but what are they going to do when they graduate? I mean, the job market's not going to be able to accommodate all these people. So, the second piece that I put in was from Forbes. It talked about how it's almost impossible to get a job in artificial intelligence now because of just demands. Different industries, especially healthcare, and just IT and stuff, are requiring their candidates to have very, very strong knowledge of AI and machine learning and stuff like that, just even before they'll even talk to you. And one thing that they didn't talk about in this article was law firms or legal departments. So for all you people that are trying to get into law school and are mortgaging your future with those those seven-figure debts that you'll be taking on just to get into law school, think about AI. Think about how you can learn more about it. Think about how you can integrate it into your practice later on, and how you can help lawyers and law firms navigate it, because it's not going away, and this will give you a leg up on your competitors when you decide to enter the job market, if you decide to go that route. So, so just those two articles together just kind of confirm what I think a lot of people have been saying about just lawyers and AI in general, that we're still in the infancy, but it's going to be there to stay. It's not going away. And if you have, a good working knowledge of it, even expertise in it, you're going to be marketable and you're going to have advantages over most lawyers.
Yeah, it struck me when I saw this story that I don't think I'm more skeptical of AI's ability to take things over. We've talked in the past. I have concerns about its ability to draw electricity, water. All these concerns are slowing down its ability to get much better than it currently is. Not that that doesn't make it helpful. That said, even with it not growing too much and getting much bigger, it does fulfill a lot of the tasks at the bottom of the law firm food chain, which
Right.
that's the problem for me. I don't think we're going to need any fewer lawyers, but when you get out of law school, it's going to start getting really tight to get a job because there's going to start being no reason for them to hire 150 1Ls or summers that become 1Ls, whatever. Because a lot of that grunt work is taken out of the problem. And then I don't know what happens because, you gotta start there to make it to being the mid-level that makes it to the senior. I mean, we built a pyramid scheme for a reason. And at that point, I think we're going to run into a lot of problems and a lot of these people are going to be left out of that.
Yeah, that's the thing that hit me when you were talking, Victor, is all these people coming out of law school, the amount of work that they traditionally did is not going to be there, maybe, maybe. But so these people could be left holding the bag and owing a lot of student debt.
I think we've got to, I think law schools, and I don't think they're going to be incentivized to do this. They need to completely restructure both the how and the what of legal educations. They need to change what they teach. They need to change the way they teach it in some situations. And then the third year, and even possibly a fourth year, needs to be an internship, right? And the intern, not just like a disability law clinic like I took, like a 1 semester thing, but an internship of 2 years, or at least 1 year, where the 1 year of the at least half of the tuition or whatever goes to the legal aid organization or the attorney or whoever it is that's going to mentor or provide an internship for this attorney, this young law student. And there's going to have to be some sort of internship or residency like the med schools have. And I realize that that's a complete restructuring. And right now there's hospitals. We don't have hospitals per se, the way that you do in medicine. But, and there's a whole structure around that makes it so that paying those residents, even though they pay them nothing, still fits into the whole structure of how the hospital works and in that system. So we don't have that in place, but somehow something has to change so that lawyers, law students get that sort of training on the ground. Third year is a waste anyway, we all know it is. So let's get some training in there and let's get them learning how to be a lawyer at that point so that they can jump in at the second level of the pyramid instead of the bottom, because the bottom's going to be full of computers, so let's just restructure.
Well, and I think too, Niki, that I agree with your point about law schools need to look at exactly what they're doing. That most law schools are designed to teach students how to be a lawyer in a large to mid-sized law firm, and that's what they do. And in the future, though, I mean, there being a lot of opportunities to Victor's point for people with a legal education to do other things in the legal marketplace, in the legal community, and in the law firm, if they have the requisite skills and understanding and knowledge how to do it. I'm afraid, though, that law schools are just like, no, we teach you how to be a lawyer, and that's all. Good luck with anything. I mean, for years they've taught no business skills, right? It's coming out. You can't even read a balance sheet when you get out of law school, and yet you operate in a business, and it's. I don't have a lot of faith in law schools and their ability to change, with a few exceptions.
I agree. I think that they're reluctant. Most of them, not all of them, are dragging their feet to even teach tech, right? Or practice management software or legal software or running your law firm, or like they're just reluctant to do any of those things. And as a result, what happens is when they do offer those classes, the students know that it's not prioritized. And so hardly anyone signs up for those classes because they understand that the school's not prioritizing it, even though it's something, and they also all think they're going to go into big law, and they're all not. like statistically, we all
Right.
know most people are going to end up maybe in big law for a year or two, and then they're not going to be for the most of their practice. They're going to likely be running their own firms or be in a small firm. So law schools are just broken, I think, and I think that we're doing a big disservice across the board. And until they're fixed somehow, which I don't see how they're going to be, I don't know what it's going to look like.
Yep. And there are a few law schools that are, I think, recognized as, Cat Moon's got program at Vanderbilt, and what they're doing at Suffolk is, that to me is where law schools need to be headed, as opposed to, this to the traditional model.
But they're not. My own law school, not to throw it under the bus, but what's happening there is just it's a regional school. I chose it because I was going to stay in upstate New York, and it prepares you to practice law regionally, in smaller.
Yeah.
And it's just not even remotely embracing tech. And I know they're trying, and there are a few professors that I've spoken to that have reached out to me about things that are actually trying to do that. But that's not the overall emphasis of the school. And I feel like most of them are like that, and it's just unfortunate.
Yeah. And it's, the professors that are probably trying to do that are not getting much cooperation from the administration of the school. But if you're, not going to have, that's a dumb idea. If you want to do it on your own time, go ahead, but we're not going to pay you to do that. Yeah.
Well, yeah,
So
no,
that pause means you have to do something.
I know, no, it was very much different for me, that moment. Yeah, no, so I think that now clears up what we had technically scheduled, I believe. The only other
And
story was,
I actually have one to talk about. I didn't have time to put it in.
perfect.
Yeah.
Perfect.
This came from our friend Doug Austin. He referenced a decision out of a judge in the Northern District of California. And so what happened was that the plaintiffs brought an action against OpenAI for copyright violations. And prior to the lawsuit, they went on ChatGPT, of all places, or I guess maybe another one of them, and they ran a bunch of prompts and inquiries about where their material had actually been used to violate the copyright. Then when they filed the lawsuit, they only cited the ones that they found where their material was actually used. And so the defendants said, well, we want all the prompts. And they said, well, when we didn't find anything, that was really like work product. And the judge was like, I don't think so. How can it be work product when you swung and missed, and not work product when you actually got a hit? I don't think that's how it works. But the real point of it was, to me, I mean, the judge was very clear, and I think it's correct, that is factual material. It's not opinion. The argument the plaintiffs were making was, by revealing the prompt that they plugged in, somehow that revealed, and I guess perhaps you could see some of that. Perhaps that revealed their strategy. But the actual response would be purely factual, I suppose. Anyway, I thought it was an interesting interesting issue that we're probably going to see a lot more of as these prompts and materials are used more. Sorry, that's the best I could do, Joe.
So what you're saying is that judge should have used Pedro's product that would help, Pablo's product that would help him like create
yeah. He would have
an opinion.
But I don't know. I mean, now that I'm sitting here thinking about it, so if you were to ask a large language model an inquiry that would, and you thought that it had been reassured that was not going to be used other places to respond to other inquiries, and you did sort of reveal some of your strategy, maybe that's not as far-fetched as I thought on first blush.
Well, but it's hard to say, right? Because it's like the whole Casey Anthony thing. It's like, okay, I'm going to Google how to drown a kid, or I'm going to Google how to do this or whatnot. It's like, well, okay, yeah. I mean, maybe that shows your intent to do it, or maybe you were just messing around, and you just like
farting around, yeah.
Yeah. I mean, or it doesn't actually mean that you actually did it. I mean, or you did it and chickened out, or it raises all kinds of questions as to like what. And plus, I mean, as a lawyer, you're supposed to like consider things that would weaken your case or that would go against what you're saying. So, if you were to type in a prompt that cut against your case, that doesn't necessarily, admit anything. It's just you're testing the strength of your case. You're being a good lawyer.
Yeah.
Yeah.
I guess the issue. The issue kind of comes in because in order to get a good response, your prompt has to be like pretty detailed. So now the more detailed it has to be, the more it could get into those kinds of thorny questions.
Yeah. And while we might look at Casey Anthony looking for how she wants to drown something, we don't ask lawyers for every one of the Westlaw searches they conducted or every Google prompt that they did using just natural stuff. So the idea that we would get all the ones just because it happens to be this new technology, especially when, as Steve mentions, these prompts tend to be more detailed and show more thinking, seems a bit much, especially when it's a lawyer doing it. I don't know. I do think that for non-lawyers, we are going to get to the point where people have a
Right.
reason to see what that is. But as a lawyer, I still kind of feel the work product deep in my
Yeah.
soul.
It
Of course,
doesn't.
the thing that got me about it all was the fact that, like I said before, when they found something good, it wasn't work product. It was only the bad shit that was work products. It kind of cuts against your argument just a little bit.
Well, I mean, it just feels to me like all the typical knee-jerk reactions to tech, like, right, with email, with the cloud, and now with AI, you need your client's permission to use it. And this is just another and then eventually those requirements go away, right? Or, you need the courts making rules about AI. And this is just like another case where AI's, the use of AI in their courts. This is just another situation where there's like this knee-jerk reaction to this tech, treating it differently than you would otherwise treat what I think is clearly attorney work product, right? Like I agree, it's akin to legal research queries. So I think that that's a little bit strange. And I did, I dropped another article that I wrote, and they're only to highlight, it's about the Walters Kluwer report. The only reason I dropped that in there is there is an interesting statistic we could at least talk about for a second, since we have a little bit of time. 60% of the respondents agreed that the generative AI will likely impact the billable hour, which I thought was interesting since we've bantered that about a lot. So I thought, since we have a few minutes, I'd highlight that. I hadn't submitted that as an article I would wanted to talk about, but thought I'd see what you guys.
What was the percentage, Niki?
60%. So it's the 2024 Walters Kluwer Future Ready Lawyer Report, and I put a link in the chat to my article, and it said quoting myself here, a surprising 60% of those surveyed expect AI-driven efficiencies to reduce the prevalence of the billable hour moving forward, and 20% predict it will have a significant impact.
So to me, the question is, what were the other 40% thinking? Oh, it never has. It never happened. It'll always be just like it is now.
Right.
And look, lawyers don't go, they don't go poor by betting against their ability to see the future. But and this goes to like we did, as Niki kind of foreshadowed there, like or alluded to there. We have talked about this a lot, including at the panel we did, the live panel we did. And I believe it was me versus Stephanie, and you're confirming that I was right, which it's a shame she's not here. But the issue, I just ultimately, the big issue for me is at a certain point, the lawyer still needs to make money. And if AI streamlines the process to take out 30-40% of the amount of build time that used to happen, are they going to pass that all along as savings to the client and therefore not buy a boat? Or are they going to find some way to get that money back? And if you can't legally charge tons of money for work that didn't really happen, then some sort of a flat fee that's more expensive is the only way around that.
Yeah, of course the other part of that though is you don't need as many lawyers, so you don't have as much lawyer expense, but you got to cut a whole lot of expenses to be able to buy that boat, right? Or airplane or whatever it's going to be.
Yeah, no, I guess if you have fewer, so like you don't need necessarily, but I don't know. I deep down think that at least any kind of service that can be remotely normalized. I think there are certain litigations that you wouldn't be able to do necessarily, but certain work you can kind of normalize how many hours that takes on average. And when AI starts cutting that into that, I think they're going to create some way to alternative fee it for maybe 10% less than they currently charge billable hour wise and call it a day.
Right.
And
Yeah.
the client says it's great, it's 10% cheaper, and the lawyers say we're doing 40% less work. So everybody's happy.
Hmm.
But
Yeah, I don't know. I tend to feel like, I've always been of the opinion that the billable hour is like MRSA, or you know, like what's something that sounds like the Juggernaut after he starts running and gets ahead of steam. Like it's, you know, people have predicted its demise a couple of times now over the last couple of decades, and it never goes away. And I mean, but I'm not saying that there's no way AI will affect it, but yeah, if it's something that's kind of like what Joe said, where it's like, everyone just says, okay, fine, we'll just cut a little bit off the top, and we'll do an alternative fee that just basically just, it's just a little bit less than what we'd be getting, then we'll just call it a day and be fine with it. And if that if you just call it like an alternative fee and not a billable hour and just go with that, then I guess, yeah, we could see some of that going forward. But I just don't think we're seeing the death of it anytime soon. Just because we've been calling it for 20 years now and it hasn't happened.
yeah, I just feel like all the previous conversations have been we should go to this alternative thing because it's a nice way to help out clients and be cheaper and whatever. And now it's how is it me as a lawyer gets to have money? And I feel like that shift of incentives to worrying about my bottom line, not the client's bottom line, changes things. Because this goes to Niki's point earlier about capitalism above all. But yeah, I like somebody's got to buy a boat somewhere.
Yeah, and you also have to, we all too often, and I'm guilty of this, I tend to think of the legal marketplace as this sort of monolithic, you know, big law firm, and everything that comes along, you look at it through that prism. But, it's really a segmented market. I mean, for the really high-end mergers and acquisitions and litigation, the proverbial bet your company, where it doesn't really matter if you spend 1,000 or 10 or 5,000 extra hours because the amount of issue is so great that who cares. That's a different market than the insurance market, where the carrier has sufficient data to say, no, Joe, that flat fee that you gave me doesn't work because our data shows you could do it for about half the price of what you're doing. So it's, there's just different marketplaces, and I think whether the billable hour will go away depends upon where in that marketplace where you're looking at.
Let's not forget P-Doom.
Yes, well, that's what I was about to say. I think we're coming to the end of our usual time. So let's go around the horn and P-Doom this. So, Niki, why don't you start since you brought it up?
All right, well, so I'm going to, with a 1 being everything's great, a 0 being everything's great, and 100 being we're all going to die, I think I'm going to put us today up at about 75, only because of the the United Health guy getting summarily executed, is what it sounds like.
Right.
In New York, and the response to that, I don't condone him getting shot, but the response to that has been interesting. And I saw a meme today that I thought very much summed up where we may be going, which was that Elon Musk had hoped to go back in time to the 1930s, and instead we're back in the French Revolution. Like, I feel like things are not looking good right now, and we may be in the midst of it's just an uprising. And I don't know where us as attorneys, who are arguably sort of near the top of that, we may not be the billionaires, but we are definitely at the top of that funnel, what that looks like for us. So I'm going to put myself at a 75.
All right, let's see, Victor.
I'm gonna go higher. I'm gonna go 85, just because I Bobby Kennedy Jr. as Secretary of Health scares the bejesus out of me. And because we've already had a couple sacrificial lambs like Gates, and then now looks like Hegseth is probably going to follow, that probably means that RFK Jr. is going to get in. And I was hoping that maybe, they would draw the line at him, but it looks like, a couple people have already kind of walked the plank. And so that means usually once that happens, everybody else gets in. And so I think he'll be okay. I think Tulsi Gabbard's going to get in. I think all these people are going to get in, and yeah, just just be careful when you buy meat products for the next 4 years. That's all.
Right.
Time to go vegan. Steve?
Yeah, I'm pretty high on the curve too. I will go with Niki's 75 just from the, everything we've talked about today. Law school applications are up, demand is going to be down. These poor guys won't have jobs, and
Just what
artificial
the world
intelligence
needs,
is
more
taking over
lawyers,
the
right?
world. And you top it all off, we have all these appointees that are probably going to get in that don't have a clue what they're doing. And I'm at 75. Although
Okay.
I could go to your 80 or 85, Victor. Wouldn't take much.
So I'm gonna be slightly more optimistic. I'm gonna sit around 50, which is very high for me. I agree with a lot of these concerns, but I still kind of have a Pollyanna-ish faith in us to work it out over the longer haul. And so I'm gonna go 50, but again, that's pretty big for me. Which I think then brings us to an end. Hey, for everybody who's watching us live, that's great. Anybody who listens to us some other way, you can watch us live. Just reach out and figure out how to do that. Otherwise, give us reviews and stuff like that on whatever podcasty thing you listened to. And that's it. Thanks, everyone. See everybody later.
Have a good weekend, everyone.
Have a good weekend.